An officer walks up to your car window, holds out a hand, and says 4 words, "I'll take your keys." No explanation, no warning, just an outstretched hand. And an assumption theirs and often yours too that you will simply hand them over, no questions asked, purely because a uniform is standing there. Here's what almost nobody knows in that moment: police do not have a general, catch-all power to simply take your car keys whenever they feel like it. Every single time this happens lawfully, there's a specific power behind it, with specific conditions attached, and often a specific warning that's supposed to be given first. And knowing that one simple fact changes the entire conversation, because it means there's a question you're entitled to ask before your hand even moves toward that ignition key. I'm a solicitor here in England and Wales, and in this video I'm going to walk you through exactly when police genuinely can take your keys, when they can't, the simple phrase to say before you hand anything over, and what happens next if your car really is seized. Let's get into it. Picture a man pulled over on a routine stop. Call him James. The officer asks for his documents. There's a query about his insurance, and then, almost as an afterthought, the officer says, "I'll need your keys." In the first version of this story, James assumes an officer's asking automatically means he has to comply, so he hands the keys over immediately, without ever finding out whether there was a genuine legal basis for it at all. It turns out there wasn't. There was simply a misunderstanding about his insurance that could have been sorted out with a phone call, and James now has to go through a lengthy process to get his own car back, purely because he never asked a single clarifying question. In the second version, James has heard somewhere that police need a warrant for everything, so when the officers explains there are genuine grounds to believe the car is uninsured, James refuses outright, holds the keys tightly, and gets into a physical tug-of-war over them. That's obstruction, and potentially worse, and James has just turned a straightforward, lawful seizure into an arrest. Same request, to completely opposite mistakes. Let's make sure you're never either version of James. Let's start with the foundation, because this is the part almost nobody knows. There is no single, standalone law in England and Wales that says a police officers may take your car keys whenever they wish. Every lawful instance of this happening traces back to one of a small number of specific statutory powers, each with its own trigger conditions. That means the phrase, "I'll take your keys," is really shorthand for something else entirely. It's shorthand for "I'm now exercising a specific power to seize this vehicle," and the keys are simply the practical mechanism for actually taking control of it. If there's no genuine power behind that sentence, there's no lawful basis for the keys to be taken at all. So before we go any further, understand the shape of what's coming. There are real, genuine situations where officers absolutely can take your keys, and we're about to go through every one of them properly. Like he's a police officer and he asked is never, on its own, one of those situations. By far the most frequently used power here is Section 165A of the Road Traffic Act 1988. This allows a constable in uniform to seize a vehicle where they have reasonable grounds to believe it's being driven without valid insurance or without a license covering that category of vehicle. Crucially, this power comes with a built-in safeguard that a lot of people don't know about. The officers must warn you first before seizing the vehicle. The constable is required to warn you that seizure will follow if you don't immediately produce your license or evidence of insurance. This isn't a courtesy, it's a legal requirement baked into Section 165A itself. If that warning genuinely wasn't given, and the circumstances didn't make it impracticable to give it, that's a real point worth raising with a solicitor afterwards. If you can produce valid documents, on the spot a genuine insurance certificate, a valid license, the power to seize simply doesn't arise in the first place. This is exactly why the simple phrase we'll cover shortly matters so much. It buys you the moment to actually check whether you can resolve the underlying issue before the keys are ever taken. The second common power is Section 59 of the Police Reform Act 2002, which allows seizure where a vehicle is being used in a manner that causes, or is likely to cause, alarm, distress, or annoyance to the public. Think dangerous, inconsiderate, or deliberately antisocial driving, rather than a straightforward paperwork issue. Just as with Section 165A, good practice under this power normally involves a warning being given first, wherever practicable, making clear that continuing the behavior will lead to seizure. This gives you a genuine opportunity to stop and avoid the seizure entirely, rather than it being sprung on you with no notice at all. The third power worth knowing is far broader in scope but requires a different kind of justification. Section 19 of the Police and Criminal Evidence Act 1984 PACE, the general power of seizure that we've covered on this channel before in relation to phones and other property. If an officer reasonably believes your vehicle itself is evidence of an offense, for example, in connection with a suspected crime rather than a routine traffic matter, it can be seized under this broader power. This is a less common scenario for an everyday driver, but it's worth knowing it exists, because the justification required is genuinely different from the insurance or antisocial use scenarios above. Here's a scenario that catches a lot of people out, because it doesn't fit neatly into the categories above. If you're stopped under Section 163 of the Road Traffic Act 1988, and the officers then has grounds to suspect you've been drinking or taking drugs, they can require a preliminary breath or drug test under Section 6 of the Road Traffic Act 1988. Refusing this without reasonable excuse is itself an offense. If that test indicates you're over the limit, or you refuse it without a valid excuse, you'll typically be arrested at that point. Once you're under arrest, the situation moves beyond the vehicle seizure powers we've discussed and into general police powers connected to a lawful arrest, which can include taking your keys as a practical, sensible step to stop you attempting to drive again, or to secure the vehicle while further steps are taken, such as it being moved or recovered from the roadside. This isn't really a separate standalone keys power so much as a natural consequence of a lawful arrest already having taken place, which is exactly why establishing your status, arrested or not, matters so much, just as we've discussed in earlier videos on this channel. It's also worth knowing that even before any arrest takes place, an officers may have a limited common law power to prevent an immediate breach of the peace or the continuation of an offense, for example, briefly holding onto keys to stop someone getting back behind the wheel while a decision is being made about next steps. This tends to be a short, practical measure rather than a long-term seizure, and it's usually followed fairly quickly by either an arrest, a formal seizure under one of the powers above, or the keys being returned once the immediate risk has passed. If you find yourself in this in-between moment, the same simple phrase still applies, asking calmly what's actually happening and what costs nothing and can only help you understand exactly where things stand. Here it is the single most useful sentence for this entire situation, and it works whether the officer's request turns out to be genuinely lawful or not. Can you tell me the specific power you're using to take my keys and the grounds for it? This single question does an enormous amount of work. It costs you nothing, it isn't confrontational, and it forces clarity before you either hand over your keys or, worse, heading to a physical disagreement over them. If the officers has a genuine, specific power in mind, Section 1658, because your insurance can't be verified, Section 59 because of how the vehicle was being driven, an arrest connected to drink driving, you'll hear it clearly, and at that point, the sensible move is to comply calmly while noting any concerns for later. If the answer is vague, I just need them for now. With no power named, no grounds given, you're entitled to say clearly, calmly, and once, I don't consent to my keys being taken without a specific legal basis, but I won't obstruct you. That second half matters just as much as the first, just as with every other power we've covered on this channel. Physically resisting pulling the keys back, refusing to hand them over once a genuine power has been properly explained risks a separate offense of obstruction. Regardless of whether the underlying power turns out to have been correctly applied, the fight over whether the seizure was actually lawful happens afterwards, with proper advice, not in a tug-of-war at the roadside. If your vehicle genuinely is seized, here's what should happen next, and what you're entitled to. You should receive a formal notice under Section 1658 seizures specifically. This is often called an RT6 notice, or simply a notice to driver, setting out the grounds for seizure and how to go about recovering the vehicle. Keep this document safe. You'll need the reference details to retrieve your car. There's a strict time limit for recovery. Vehicles seized under Section 165 generally must be reclaimed within 14 days, or the police can proceed to dispose of or destroy the vehicle. This is a genuinely tight window, and it's one of the most important practical details in this entire video. Don't assume you have unlimited time to sort things out. You'll typically need to produce valid documents to get it back. This usually means attending a nominated police station with valid insurance and a valid license, so the details can be checked against DVLA and the Motor Insurers Bureau before the vehicle is released. There will be recovery and storage charges. These fees are set out in regulations and can increase the longer the vehicle sits in storage, so acting quickly matters, both for the 14-day deadline and to keep costs down. Sometimes, despite everything above, a seizure turns out to have been based on a genuine mistake, a lapsed record that had actually been renewed, a license category that was, in fact, valid, or a warning that was never properly given in circumstances where it clearly could have been. If this happens to you, the roadside is never the place to resolve it. As we've said throughout this video, that fight happens afterwards. Your options include making a formal complaint to the police first involved, and in more serious or costly cases, exploring a legal challenge through the court regarding the lawfulness of the seizure itself. A solicitor can help assess whether the specific conditions of Section 165A, Section 59, or whichever power was relied upon were genuinely met at the time, based on the notice you were given and your own account of what happened. Keep every piece of paperwork you're given. Note down times and locations as accurately as you can while the details are still fresh. And if you have dashcam footage or any other independent record of the stop, preserve it rather than allowing it to be overwritten. It can make a genuine difference to how convincingly a later challenge can be put together. A few quick things worth avoiding, because I see people trip over these constantly. Don't physically resist, even if you're certain you're right. As we've covered, obstruction is a separate offense, and it exists regardless of whether the underlying power turns out to have been correctly used. Winning the legal argument later is far better than winning a physical struggle over car keys in the moment. Don't argue the finer points of Section 165A at the roadside. Ask the simple phrase, listen to the answer, and if it's genuinely unclear or you disagree, note your objection calmly and move the real argument to a solicitor's office, not the side of the road. Don't ignore the 14-day recovery window. This is a hard, practical deadline, and missing it can mean losing your vehicle for good, regardless of whether the original seizure was fully justified. Don't assume a request to search your vehicle and a request for your keys are the same thing. We've covered vehicle searches in a previous video on this channel. That's a separate power with its own separate conditions, and that shouldn't be treated as one and the same simply because they both involve your car. Before we move to the recap, let me address the scenarios that come up constantly whenever I discuss this topic. What if it's not your car? A lot of people drive vehicles registered to a partner, a parent, or a friend. The powers we've covered above generally attach to how the vehicle is being used at the time, not strictly to who the registered keeper is. If you're the one driving, without valid insurance or a valid license, Section 165A can still apply to the vehicle in your hands, regardless of whose name is on the registration document. This can feel deeply unfair if you genuinely believed you were covered under someone else's policy, but it's exactly the kind of misunderstanding worth raising immediately, on the spot, using the simple phrase, because sorting out a genuine misunderstanding about insurance cover before the vehicle is actually seized is far easier than trying to unwind it afterwards. What if you're a passenger, not the driver? If you're simply a passenger and the vehicle is seized because of the driver's documents or conduct, you're not personally responsible for that seizure, but you will need to make your own arrangements to continue your journey, since the practical seizure powers attach to the vehicle itself, not to who happened to be sitting in it. It's worth knowing this distinction clearly, particularly if you're a learner driver being supervised or sharing a long journey with friends, since responsibility for the vehicle's documents generally sits with whoever was actually driving at the time, not with everyone inside it. It's worth taking a moment to explain exactly why this one calm question works so much better than either of the two mistakes we opened this video with. When you simply hand over your keys without asking anything, you lose the opportunity to resolve a genuine misunderstanding on the spot, a lapsed policy that was, in fact, renewed that same morning, a license category confusion that a quick conversation could clear up entirely. Once the vehicle is seized, you're now dealing with a formal process, a fee, a 14-day deadline, and a genuine inconvenience. for a problem that might never have needed to become a problem at all. When you refuse outright and get physical about it, you convert a civil, procedural matter, the seizure of a vehicle, into a criminal one, specifically the offense of obstructing a constable in the execution of their duty. That's an entirely avoidable outcome, and it's one that can follow you far longer than any inconvenience connected to the vehicle itself ever would. The simple phrase sits precisely between these two extremes. It costs you nothing, it doesn't slow down a genuinely lawful process, and it gives you the best possible chance of resolving a genuine mistake before it turns into a formal seizure while still protecting you fully if the power turns out to be entirely justified. Let's walk through how this should actually play out. An officer's asked for your keys. Before handing them over, you ask calmly, "Can you tell me the specific power you're using and the grounds for it?" If a genuine power is named, no valid insurance, antisocial driving, an arrest already in place, you comply calmly, note the details, and keep any formal notice you're given safe. If the answer is vague or no power is named at all, you state clearly that you don't consent, without physically obstructing anything, and you raise the issue properly afterwards. Either way, if your vehicle does end up seized, you move quickly, checking the notice, gathering your documents, and working within that 14-day window before it becomes a much bigger problem than it needed to be. Let's bring it all together. Remember the default. There's no general catch-all power for police to simply take your keys. Every genuine instance traces back to a specific law with specific conditions. Remember the main powers, Section 165A of the Road Traffic Act for no insurance or license, with a required warning beforehand. Section 59 of the Police Reform Act for antisocial use. Section 19 of PACE, where the vehicle itself is evidence, and the practical consequence of a lawful arrest, most often connected to drink or drug driving. Remember the simple phrase, "Can you tell me the specific power you're using to take my keys and the grounds for it?" One calm question that turns guessing into knowing every single time. Remember to comply with a genuine power while noting your concerns for later, and to never physically resist, regardless of how confident you feel in the moment. And remember, if your vehicle is seized, the clock is running. A formal notice, valid documents, and that strict 14-day recovery window are the practical details matter most once the roadside conversation is over. And remember that to special situations worth keeping in mind, the powers generally attached to how the vehicle is being used, not simply to whose name is on the registration document. And a passenger isn't personally responsible for a seizure connected to the driver's documents, even though it will still disrupt their journey. Because here's the truth underneath all of it. In that moment, with a hand held out for your keys, the officers is very often relying on exactly one thing. You don't know there's a question worth asking before you simply comply. The moment you ask it, calmly and clearly, the entire encounter changes. It doesn't slow down a genuinely lawful process by more than a few seconds, and it gives you the very best chance of catching a genuine mistake before it turns into a formal seizure, a fee, and a fortnight without your own car. Know your rights, because the people who know them are the ones who keep their cars, their money, and their dignity, whatever the outcome turns out to be. I'll see you in the next one. This video is for general information only and does not constitute legal advice. Every situation is different. If you're facing a specific case involving vehicle seizure, speak to a qualified solicitor as soon as possible.